Companies Act, Section 220, Seizure of Documents by Inspector. Section 220 of the Companies Act, 2013 outlines the procedure for an inspector to seize documents and books during the course of an investigation into a company or other related body's corporate. This provision is critical for ensuring that relevant documents and evidence are preserved, especially when there is a reasonable belief that such materials may be destroyed, altered, or falsified to hinder or obstruct the investigation. It grants the inspector the authority to take swift action to secure these documents and preserve the integrity of the investigation. 1. Grounds for seizure of documents. Subsection 1 of Section 220 provides the grounds under which an inspector can seize the books and papers of a company or any related entity. It stipulates that if, during the course of the investigation, the inspector has reasonable grounds to believe that the documents or books in question may be destroyed, mutilated, altered, falsified, secreted, the inspector is authorized to take immediate action. This ensures that critical evidence is preserved and that any attempts to obstruct or tamper with the investigation are thwarted. The specific actions the inspector may take include: A. Entry into premises. The inspector may enter the place or places where the books and papers are stored or kept. To carry out this action effectively, the inspector can seek the necessary assistance, which may include security personnel or technical experts, depending on the circumstances. The goal is to ensure that the documents are accessed in a manner that allows the inspector to seize them without delay or resistance. B. Seizure of documents. Once inside the premises, the inspector may seize the books and papers that are deemed necessary for the investigation. However, the company or other concerned party is given an opportunity to take copies of or extracts from the seized books and papers at their own cost. This provision ensures that while the inspector secures the necessary documents, the company is not unduly deprived of access to the information and can still continue its operations or defend itself, if needed. This process of seizing documents allows the inspector to ensure the integrity of the investigation, preventing any further destruction or alteration of important evidence while also respecting the rights of the company to access and retain copies of the relevant materials. 2. Custody and return of seized documents. Once the inspector has seized the necessary books and papers, subsection 2 governs how long these documents will be kept in custody. The key points regarding the seizure and return of the documents are as follows. Custody period. The inspector is allowed to retain the seized documents for a period that is deemed necessary for the investigation. This period will not extend beyond the conclusion of the investigation. The inspector must ensure that the documents are secured until they are no longer needed for the investigation. Return of documents. After the investigation concludes, the inspector must return the seized books and papers to the company, the other body corporate, or, in some cases, the managing director or manager from whom the documents were originally seized. Provisions for document handling before return. Before returning the seized documents, the inspector has the authority to take additional steps if necessary. These steps may include taking copies of or extracts from the documents, marking the documents with identification marks or taking other steps to preserve the integrity of the evidence. These actions allow the inspector to document and maintain a record of the evidence, ensuring that it is not tampered with and remains useful for any potential legal proceedings or further investigations. 3. Applicability of the Code of Criminal Procedure. Subsection 3 makes a key reference to the Code of Criminal Procedure, 1973, CRPC, specifically in relation to searches and seizures. It states that the provisions of the CRPC regarding searches and seizures shall apply mutatis mutandis, with necessary modifications, to every search or seizure made under Section 220 of the Companies Act. This means that the procedures followed during the search and seizure of documents under this section will adhere to the same standards and protocols established by the CRPC, which is a well-defined set of rules that govern the conduct of searches, seizures, and the treatment of seized materials. This ensures that the seizure process is legally sound, transparent, and compliant with established criminal law standards. For more details, contact us.